I have a link for that. At least I hope so. There's the link to the Mont Guide, the MSU Extension Mont Guide for provider orders for life-sustaining treatment. It is not my favorite document, but that is basically just me whining because, like I said, pretty much every facility, to my knowledge, all facilities are now using this document upon admission, whether it's a hospital or a nursing home. Whenever somebody is admitted, they have to go over this Polst form. And the purpose of the Polst form is so that someone can decide what treatment they want when they're in a dying situation. It's end-of-life planning for the healthcare facility. In that respect, it's a good idea. But the problem is it was only intended as a living will type situation, like an literally end of life, where death is coming in a relatively short period of time. When it was first developed in Oregon, I want to say 15 years, maybe even 20 years ago now, that's what the document was intended. Unfortunately, it's now being used in a far broader range of applications. And by that I mean they have you sign this thing when you're admitted to a facility, and you check a box based on what you think the type of care you're going to need, and then they use that when something bad happens a year and a half down the road, or when your condition changes. And the form was never meant to address changing conditions or changing treatment wishes. In fact, it's amazing to me that the words life-sustaining treatment are not even in this document, except for in the title, which is noteworthy. But it's not, nowhere is life-sustaining treatment in this document. It's not even in the instructions for the document. So recall back to when we were discussing the living will, and I said that life-sustaining treatment is treatment that's not helping your condition. It's just prolonging the dying process. Well, I have heard of at least 3 incidences over the last 5 years where facilities were not giving someone treatment based on this form, even when the treatment was going to resolve the condition. A gentleman had a bowel obstruction, and the facility thought that because of the Polst form, they weren't supposed to treat that condition. Someone had a concussion, and it was a brain bleed causing pressure on the brain, and a hospital actually in western Montana was not going to treat that because of the Polst form. Clearly a misconception. I'm just afraid, unless that's a problem that could arise more and more frequently, since this form is so widespread. So when I'm dealing with estate planning documents, I definitely advise people to be aware of that issue. Most facilities require the Polst upon admission, so you may or may not be able to get around it. It definitely does not replace the living will, and so that's just kind of a heads up for everybody. How am I doing for time? Quick, amusing note on the living will. Years ago in Montana, and I apologize I don't have a site, there was a case where a gentleman had it was actually a DNR, a do not resuscitate, and he had a bracelet on the way he was supposed to in a doctor's order, providing that emergency providers were not supposed to revive him by CPR in the case of a cardiac event. Well, through the negligence of the emergency responders, they did not see his DNR notice or his bracelet. I can't remember if it was a bracelet or not, but they did not see the notice, and so they revived him. Well, he sued. He said, that was negligent for you to save my life. And interestingly enough, it went all the way up to the Montana Supreme Court, and he won. And they now call it the wrongful life case as opposed to a wrongful death case. And he won. The court decided that he was in fact correct. They violated the law and were negligent. But the damages they awarded were nominal. They awarded him $1 in damages, and so I think that's amusing. Obviously, the lesson is, if you're advising any healthcare provider, err on the side of saving someone's life, which should have been a no-brainer even before that case, probably. All right, on that note, let's move on to the Homestead Declaration.